The last category we're going to cover is compensation laws, and they are also considered equal employment laws, but they're specifically addressing issues of compensation, and they're unique to issues of compensation. And the first one we should be aware of is the Fair Labor Standards Act. And in the Fair Labor Standards Act, they have a couple of different issues that they address. Number one is overtime, who is eligible for overtime, who is not, and if they're going to have overtime, what are they allowed to charge? And what should an employee be paid for that overtime. If you look under where it says exempt employees overview, it's a hot link. You should be able to access that in the slideshow. If not, I can make sure that I review this in class. But the exempt employees goes into detail about what exactly involves being a professional or an administrator or an executive or an outside sales rep. And it goes into some detail about that. In terms of what is overtime, again, overtime compliance, it is important to recognize when do we give overtime and under what circumstances and what does it need to look like in terms of wages and things like that. The next thing that the Fair Labor Standards Act covers is minimum wage. What is considered to be the minimum wage? And obviously that's in debate right now. You know, if you've been listening to Missouri, the state of Missouri said that no municipality can have a minimum wage that's higher than the state wage. And so the courts have knocked down the city of St. Louis's new rate, which is going to be higher than the state minimum. Interesting to see, you know, how the courts are going to be playing out. But there are minimum wages that vary from state to state, and again, with this slide, you can hot link onto that minimum wage by state and see what the minimum wage is in the state and when it will be phased in over time. The last thing that FLSA does is deal with child labor protections and child labor restrictions. You all remember, you know, if you're under 18, being able to work, you have to have certain permission from your employer. You can only work certain hours, up to a certain hour per night, and you're given the opportunity to work in that way. Again, the role of the FLSA was to make sure we didn't have children working, you know, full-time jobs in manufacturing environments, which was the case at the turn of the 20th century. So the child labor restrictions say, children under 18 can't work in an unsafe environment. They can't work with forklifts and things like that. They can't work in an environment where there's a high risk of injury. They can only work certain hours. I mean, kids can work on farms, family businesses. It's a very different factor, but there is some restrictions on the number of hours that they can work. Once you hit 18, then you're able to continue to work at different rates. But we do try to manage, under a certain age, what work that children can and should be doing, so that they get an education and they stay safe and they get to grow up, and so that it doesn't become a problem for them. The Civil Rights Act did argue that employers cannot pay an employee in any way or shape or form on any factor other than their job performance. There are a few exceptions to that, and you can see what those lists of exceptions are. But generally speaking, you don't pay someone and give raises to them unless it's related to their actual job performance. So what are the exceptions to that? Well, if your company has very strict pay ranges, right, and you're at the top of the pay range, you can't get a large raise because you're at the top of the pay range. The company, doesn't want to exceed their pay range. You can't exceed the maximum amount of dollars in that pay range. You're not going to get a raise. You're going to sit at that until the company adjusts the pay ranges and the pay line. So you may get stuck not getting the high raises that you want. You can also say, well, you can get a pay raise that may be different than you would if you got an annual raise. If you haven't gotten a raise for a few years, like for example here at SIUE, we haven't gotten a raise here for a few years, but perhaps when it gets reinstated, we may find that the decision to increase our pay may not be related to our last pay increase or to performance. It may be actually because we haven't had pay in a long time. They might do across the board, pay increase for everybody. We don't know. I doubt we'll ever get a raise at this point. I may be making what I'm making for the rest of my life. Who knows? But we'll see. The size of the last increase, again, if you give a nominal raise to someone just to kind of say thank you, it doesn't have to necessarily be based on their job performance. It could be because we can only give you a small raise. It's all we can afford, and it's more of a an acknowledgement that people have done work and we want to do whatever we can to help, but it may not be based on your overall performance. It's not really going to reflect your overall performance. Another aspect would be internal consistency. We want to make sure that people with lower skilled jobs are making less money than those with higher skilled jobs. And we want to make sure that women and men and majority and minority groups are being paid at the same rate for similar jobs. And we still find, even in a lot of places, when you control for experience, when you control for age, when you control for education, women still make less money than men do in higher education, for example. And it has nothing to do with disciplines. It just simply has to do with the fact that the only differentiating factor is men versus women. And it's really stunning when you see that. Lastly, external competitiveness. I mean, if you look at a school like SIUE, which school do you think makes the most money? Do you think it's the dental school, the pharmacy, business, engineering? The ones that make the most money are School of Dental Medicine and School of Pharmacy. Why? Because there's enormous pressure for people to stay in academia and to teach in those areas, and so they have to pay faculty enough money to attract them and to keep them in academia, as opposed to working in industry where they can make way more money. So they have to pay them at a rate in order to be able to attract them and to keep them working in academia. And then after that comes the School of Business, then the School of Engineering, and then the other schools, sort of follow suit behind that in terms of their rate of pay. And again, when there's job opportunities outside of academia, you have to pay people more money in academia to keep them in here. Philosophy, there aren't external pressures for philosophers to have jobs outside of academia. With business there is. For art, again, not a lot of draw to have people working in higher ed, jobs in art outside of higher education. You can do your own art and sell your own art, but there's not a job that would pay the same rate as doing one in higher ed would. And so this is the same sort of thing. And it feels unfair. A friend of mine who's in Islamic literature, and she doesn't make as much money as I do, and she's had her doctorate way longer than I did. But she still didn't make as much money as I did as my starting salary, because I have a degree in business and there's pressure for me to keep me in academia as opposed to going into industry where I could make more money. Versus in Islamic literature, there is no external pressure to do that. When we have a job candidate that we really want, and we know that there's a high pressure to hire this person, and there's a lot of offers, we may make them a large offer that's unrelated to their ability to do the job, simply because we want them to come work for us. And we know that they'll do a good job, and so we want to attract them to our company. So that competitiveness externally can also drive our decision to pay people differentially. Otherwise, except for those exceptions, we need to pay people based on their performance, no other factors other than that. We don't pay them based on race or sex or religion or things like that. A lot of compensation law deals with issues of benefits, so you should be aware of a couple of these laws and how they affect us. Number one, Pregnancy with Discrimination Act. We talked about this already. It means that we need to treat pregnancy like a short-term disability, which is a form of a benefit, and that our health care coverage has to cover pregnancy and childbirth and things like that, so it has to be covered. The Americans with Disabilities Act, as we talked about, covers people with a disability, and how this affects benefits is that we want to make sure that just because someone has a workers' comp claim, that it doesn't prohibit them from getting a job. So we may know, we can't ask them their workers' comp history before we offer them the job. We can ask them later and see whether or not that there's a history of someone getting injured and scamming companies, because it does happen. But an applicant cannot be asked about their workers' comp history. They have to be offered the job, and then that history has to be forthcoming afterwards. Family and Medical Leave Act basically says we need to give people, employers, 50 or more employees have to give their employees up to 12 weeks unpaid leave for illness, birth, adoption, or caring for another person in your family who is ill. Some of the challenges around the Family and Medical Leave Act is, how do you define a family when you've got same-sex couples who have children together but they may not be legally married, or even any heterosexual couples that are not legally married. Are they considered a family unit? Or is it only a family based on the definition according to the federal government? Another thing that's an issue is right now it's unpaid leave, and there is a lot of movement and a lot of discussion about making it paid leave. Certainly, we know a lot of Scandinavian countries and European countries have paid leave for maternity and stuff like that, so why shouldn't we offer the same here? The last thing you should know about that is the top 5% of the company, in terms of the hierarchy, are not eligible necessarily for Family and Medical Leave Act because it's very difficult to replace them. It doesn't mean that we can't offer it to them, it just means we're not legally mandated to offer it to them. And I don't know any company that would not give their senior executives the time off that they need, for any of these particular issues. It's just that the company is not legally mandated to do it. And that was a concession that was made, so it didn't become a hardship for employers. A few other legal issues around employee benefits. In terms of the Age Discrimination and Employment Act, we can't deny benefits to anybody who's over the age of 40 or offer them different benefits because they're over 40. So again, we don't want to have an adverse impact on them where we're having benefits that cost them way more money because they happen to be older. And so we don't want to have differential impact on them in that way. The ERISA, the Employee Retirement Income Security Act, basically says that people's pensions should be covered by the Pension Benefit Guaranty Corporation, the PBGC, and it works very much like the FDIC, right, for banks, where it guarantees your money will be safe up to a certain amount of money. And that the PBGC, if the company folds, PBGC will, and the money disappears, the PBGC will honor that up to a certain amount of money. ERISA also says what companies can or cannot do regarding their pension plans in terms of their fiduciary responsibilities. And the ERISA also said that after an employee is fully vested, they've worked there for 5 years, they have the right to 100% of their benefits. And companies can accrue the benefits any way they want to over that 5 years. Some companies do a flat rate where it's 20, 20, 20, 20, so that you get 20 the first year, 40 the next, 60 after that, 80, and then 100% of your benefits of your money that's not invested. I can get 100% of my money at any time. But if the company matches it, you can only, the first year you get 20% of that if you leave. The second year you get 40 and you work your way up. And others do it in an accelerated way where you get low in the beginning and they encourage you to stay, so it becomes, you accelerate. The longer you stay, the larger the percentages are over time as you get that. So, and the goal here is they don't want people to leave and take all of their money with them, right? All these accrued benefits. They're saying, look, you've got to show us that you want to stay here and work here in order for us to give you full right to all of your pension benefits. And then you can understand that. It's a turnover issue. So ERISA works that way. It's a very complex legislation. It's hard to even get into the nitty-gritty on that, but you should have an entire legal system set up just to manage the ERISA plans because they are complex. But lastly, on this page is the Economic Recovery Tax Act, which allows us to set aside money pre-tax for dependent care, medical spending accounts, things like that. And so these Recovery Tax Acts are really about giving us sort of lower our tax liability in order to manage things that we have to manage, like our medical spending. Medical expenses are going up, and so even though we're capped at $2,500 for our medical spending accounts, it used to be more, and now we're capped at $2,500. Still, it's challenging, right? It's challenging to do this. But the same thing for dependent care. We know the dependent care accounts are basically, we take the money out pre-tax and then we are taxed at a lower tax rate. So we still get the same money to pay for our daycare for our children and any kind of dependent care for our children, but at least we don't have the higher tax liability to do those things. The last two sort of issues to be aware of, number one, COBRA 1985. COBRA still holds. It requires private employers to offer health care benefits to their employees who are terminated or laid off or retired. They usually can get these benefits for up to 18 months in many ways as a transition to either another job with another set of benefits or to Medicare, if that's appropriate, whatever it is. And it was much more salient early on in 85 and the 90s and even in the early 2000s before the Affordable Care Act came into place because it was very expensive to buy plans on your own, and COBRA, at least was a more reasonable cost to keep your insurance, particularly if you needed your insurance. And if you had a pre-existing condition, losing your health insurance is a big issue. It becomes less salient now, still important, but less so because of the Affordable Care Act, because we now can buy bridge policies, if you will, through the market, because when you lose your job, it's a change of status, and a change of status then triggers the Affordable Care Act. I can go into the market and I can buy a policy on my own. HIPAA was Bill Clinton's compromise when they couldn't get health care reform passed. They built in the Health Insurance Portability and Accountability Act, which basically said it started to eliminate some of the restrictions on pre-existing conditions. And before that time, if you had a major disease, if you had multiple sclerosis or diabetes or things like that, and you were under care, when you went to a different employer, they might not cover any of your care regarding your diabetes or your MS or things like that. They would cover everything else, but those things would not be covered, and you'd have to pay out of pocket for those medical expenses, and that got very expensive. So it became a disincentive for people to leave their jobs, and then they felt trapped working for jobs that they didn't like, or they weren't getting the advancement that they want because they had these pre-existing conditions. Now, there were still some constraints on that. It really wasn't until the Affordable Care Act passed that we really got rid of all those constraints. You can absolutely get anything covered. It may cost you a little bit more money, but you can get everything covered at this point in time. So speaking now of the Affordable Care Act, this passed in 2010. It enables people to keep their kids on their insurance until the age of 26. And again, if they're in grad school, this is very helpful, right? Or if they are in jobs, in entry-level jobs that don't really have good benefits, this is a benefit for them as well. It makes sure that insurance plans cover, some plans cover 100% coverage for any preventative services. It makes sure that they have to price and sell policies to anyone regardless of their pre-existing conditions. There are subsidies available for people who working at up to 400% of the federal poverty level, depending on what size your family is, obviously. That's where it's contingent upon. But if you make more than that, then you wouldn't be eligible for the subsidy, but nonetheless it still could be available for you. The goal is that nearly all Americans will have to have the insurance, and if you don't have it, it's fine, but you'll be taxed for it. And obviously, as we know, the Supreme Court supported that it is a tax, that you'll have to pay a tax for the fact that you don't have that insurance. So you can continue to not have it, but you have to pay the tax. Companies that have fewer than 25 employees will be eligible for the tax credits. And also anybody that employ 50 or older have to make sure that that they offer benefits. If they don't provide it, they're going to be fined or taxed themselves. And the federal government said there has to be minimum standards. Now, that's one of the big to-dos, in terms of the way that the ACA got rolled out. It really wasn't communicated clearly enough that they had to meet some minimum standards, because a lot of people said, hey, you said if I like my plan, I could keep it. Well, I like my plan, and you're not letting me keep it because it doesn't meet your minimum standards. And therein lies the problem. It was a communication issue, but that was an important part of the law right from the beginning. People should be allowed to keep the insurance they want, but only if it meets the certain standards. You can't have a lousy plan, when it doesn't meet your standards. But I know an enormous number of people who were able to get good insurance under this, and there are way more insured people now, and it has brought the cost of healthcare down somewhat, and will continue to do so over the next few years. Our last slide is regarding workers' compensation, and workers' compensation is the insurance that we take out to help us replace the wages and medical benefits that we need if we're injured on the job. And so if in the course of doing your job you get injured, workers' comp is supposed to cover that. And I say supposed to because we see a lot more challenges to workers' comp. A lot of employers really challenge whether or not someone was injured on the job, if they had a pre-existing condition that might have made them prone to having that injury. So there becomes issues of joint liabilities and things like that. What it should have been, and I think a lot of employers and a lot of people are still fighting for, is to make it a no-fault policy where the employee relinquishes their right to sue in order for them to be compensated, and so that I'm not going to sue you for a tort of negligence as long as you are willing to cover the cost of whatever the expense is, and I'll agree to perhaps less money than I might get if I sue, because there's a no fault guarantee here. I'm not going to come after you for more money, and I'm not going to sue you. You're going to just cover my costs, and we're going to go on with it. And workers' comp obviously varies from state to state. The provisions vary. You can see that on your PowerPoint slide. You can click on that link. There are some new trends. There was an interesting interviews on NPR in the last couple of weeks talking about opt-out programs. Texas and Oklahoma have plans where the employers can opt out of workers' comp and develop their own workplace injury plans. But these workplace injury plans, they're finding more and more are subpar, and that people are not getting the benefits that they want. Their benefits are cut off much sooner than they would be under normal workers' comp claims. And through some investigations, they've already seen that most of the Oklahoma plans under these opt-out programs violate the law. And people feel like their hands are tied. There's very little they can do. I mean, there are people that are injured on the job. It's very obvious they get injured on the job. And then they injure their back, and then they're told to go to an ear, nose, and throat doc. And the ear, nose, and throat doc says, I can't help you, go to a back doc. And then their insurance plans tell them, well, no, you're not eligible to go to that back doctor. You're only eligible to go to this doctor. And it's ridiculous. I mean, there's some horror stories out there about these opt-out programs. If anybody's worked in the area of workers' comp, yes, there is abuse. There's no doubt about it. There are people that abuse the system all the time. There are people that abuse all sorts of systems. There are corporations that abuse all sorts of systems. Let's be real, right? But a lot of employers do fight their employees and try to make the case that they were not injured on the job, that they were not sick. And it's really stunning to see it in action. And I've had some personal experience with this, watching someone that I cared about, go through workers' comp, and it's a pretty horrid experience because they really do their best to diminish you and call you a liar, that you weren't really injured at all. So it is challenging. So. Just so you're aware, workers' comp, and it's not meant to replace your full wages, but it's meant to replace a proportion of them to help you to get through, to make sure that you can survive while you're off work because you were injured on the job. That's the goal of it. So this covers the very extensive lecture on employment law, and please bring your questions to class.